Before we dive into this case, let's set the stage. Today, we are inside a Texas courtroom with defendant Jacqueline Sanchez, facing serious charges for drug possession. Now, this isn't just about a single mistake. What unfolds here is a rollercoaster of courtroom drama, plea deals, emotional confessions, failed drug tests, and ultimately, a battle between second chances and accountability. The prosecution, the defense, and the judge all pull in different directions, and Sanchez herself reveals shocking details about her addiction, her struggles, and even her family. Stick with me, because this case has everything: tough legal rulings, gut-punching personal revelations, and a twist at sentencing you won't see coming. Let's break it all down.
And are you Ms. Sanchez?
Yes.
Did you understand in count 2 you're charged with possession of a controlled...
Notice here, the judge wastes no time explaining the gravity of the charge: possession of a controlled substance, between 4 and 200 grams. That's not minor. We are talking about a penalty that carries 2 to 20 years in prison. What's crucial here is the mention of deferred adjudication. That's basically a legal lifeline. If Sanchez follows the rules, avoids violations, and completes probation, she could walk away without a conviction on her record. But if she slips up, the hammer drops, and she's staring at a full prison sentence. It's a razor-thin tightrope walk.
Substance penalty group 1, 4 grams to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Next, I'm going to show you the plea bargain page. Did you review that page with your attorney, and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 2. They're asking for a $1,000 fine. They're recommending deferred adjudication. There's to be restitution of $57 to San Antonio Police Department for laboratory testing. Did you understand that to be the...
Here's where things get really interesting. The plea bargain offers a $1,000 fine, $57 in restitution for lab testing, and deferred adjudication with conditions like treatment and community service. Sounds manageable, right? But remember, every single condition is a trapdoor. Miss even one requirement, whether it's a drug test or a payment, and Sanchez risks having this entire deal revoked. This shows how the justice system often balances leniency with strict accountability. She's being given a chance, but the court is making crystal clear, it's one strike and you're out.
Plea bargain agreement.
Yes, ma'am.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation and 80 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense is charged in count 2. How do you plead? Guilty, not guilty, or no contest?
No contest.
Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, Ms. Sanchez has been here. We looked at all the evidence. We discussed some of the motions to suppress that she accepted it. She's taking responsibility. We just ask that you follow the plea agreement, Judge.
All right. Ms. Sanchez, are you employed?
Not yet, ma'am.
How are you supporting yourself?
I'm right. I just recently I lost my apartment, so right now I am staying with a friend.
Who is this friend?
My friend Vivian.
All right. If you're drug tested today, what are the results going to be? And before you answer, know that I am going to drug test you today. So what are the results going to be?
And there it is, the turning point. When asked about a drug test, Sanchez doesn't deny it. She admits flat out, "I'll be dirty for marijuana." But then hesitates, hinting at something more. The judge presses, "And what else?" This is where honesty collides with addiction. For the court, every word here matters. Judges listen closely not just for truth, but for consistency. Any vagueness can be read as dishonesty or minimization. This moment sets the tone for how the judge will view her credibility moving forward. What do you think? Was she being honest enough, or already digging a deeper hole?
I will, I'm gonna be honest, I will be dirty from marijuana, ma'am.
And what else? It's
And
more
that's
than
it.
marijuana.
No, I know, but that's it, ma'am.
When's the last, well, let's do it this way. What could you possibly be positive for if you're drug tested today, and you will be drug tested today?
I know marijuana for sure.
And what else? That's a maybe.
Maybe meth, but I have not done that, ma'am. It's been about 5 days, 6 days that I have done that. I'm letting that go. I just want to start working, get my life together, and finish my probation successfully.
Do you have any children?
I do.
What are their ages?
Now the stakes rise even higher. Sanchez reveals she has multiple children, including a 17-year-old daughter, who's living with her boyfriend because of their eviction. The courtroom atmosphere shifts here. It's no longer just about drugs and probation, it's about family stability. Judges often weigh these personal circumstances heavily. A defendant with dependent children is under added scrutiny because their choices affect not just themselves, but their kids' futures. For viewers, this begs the question, should the court show more compassion in light of her hardships, or should her role as a parent mean she's held to an even higher standard?
24, 25, my daughter's 25, yeah, she just turned 25. 19, 18, and my daughter's going to be 17 next month, my youngest.
All right, and where is your 17-year-old?
Right now, she should be at work. She's working.
Well, where does she live?
She lives with her boyfriend right now. Because we had got evicted of our apartment, so she's staying there right now, and I'm right here. I'm just trying to go. I'm trying to go back to work, but my car right now, the car belt went out. So, I already did my application. I just need to pick up my client. I was gonna be a care provider.
This part is critical. Sanchez says she was about to become a care provider. Immediately, the judge cuts her off. No, you're not going to be a care provider anymore. Why? Because she's still actively struggling with addiction. The judge delivers a powerful analogy. Would you want your grandmother cared for by someone battling meth and marijuana use? This is a teaching moment not just for Sanchez, but for everyone watching. The law doesn't just punish, it protects vulnerable populations. And the judge makes it clear, trust and responsibility are privileges that must be earned.
No, you're not going to be a care provider anymore. Do you understand why?
Because of my case.
Well, because you're active in your addiction. And I can't have someone who's active in their addiction, who has felony cases, being a provider for vulnerable people in our society.
When would I go over to approve that?
Let me ask you this, Ms. Sanchez. If you had a grandmother who needed someone to care for them, and if it were going to be me, and I told you I had a meth problem and a marijuana problem, and I'm probably going to test positive for marijuana and maybe meth, would you want me looking after your grandmother?
No, ma'am. I completely understand. That's what I'm saying. If my UAs are good, successfully, can I go back to that?
No.
No.
Because let me just explain this to you. Would you want me, if I'm maybe going to test positive for meth or marijuana, to be in a home with your grandmother who may have valuable items? And you know what happens when you don't have employment, right? You have an addiction and there are valuable items around. So this is what the court is going to do. 3 years deferred adjudication, $1,000 fine probated, $57 for laboratory testing, 80 hours of community service restitution. 40 of those hours will be waived if you provide proof of your COVID vaccination. The court is not requiring that, but if you do, 40 hours will be deducted. There's to be no unsupervised contact with minors, a referral to felony drug court. If she's not accepted into felony drug court, then it's going to be intensive outpatient treatment with probation, proof of employment within 30 days, no employment as a home healthcare provider or with minors, field visits 2 times per month, random, UA hotline until accepted, in a drug program. Ms. Sanchez, is there anything else you need from the court in order to be successful?
No, ma'am.
Court is calling.
Let's break down this ruling. Sanchez is given 3 years deferred adjudication, $1,000 fine, community service, drug testing, proof of employment, and strict restrictions on jobs involving children or the elderly. Notice the COVID vaccination clause, 40 hours waived if she provides proof. That's not politics, it's about encouraging accountability and compliance. Judges sometimes use these small incentives to push defendants toward better habits. What's striking is how comprehensive these conditions are. They are not just punishment, they are a roadmap. But as we'll see later, following that map is far harder than it sounds.
2021 CR 7498, State of Texas versus Jacqueline C. Sanchez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Inquiry for Jacqueline Sanchez, defendant, Your Honor.
Are you Ms. Sanchez?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes.
Are you the same Jacqueline C. Sanchez who was placed on deferred adjudication in 2021 CR 7498 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on December 10th, 2021 for a period of 3 years? Is that you?
Fast forward to 2024, Sanchez is back in court, but this time it's worse. She admits she violated probation by failing a drug test. That single admission changes everything. Remember what we said earlier about deferred adjudication. This is the trap door. By pleading true, she acknowledges she broke the agreement, and now the judge has full power to revoke her probation and impose up to 20 years. Think about that. One missed test can erase years of second chances. Should courts be this strict, or is it necessary to maintain accountability?
Yes, ma'am.
All right, state.
Violated condition number 2, on or about the 12th day of February 2024 in Bexar County, Texas, the defendant, Jacqueline C. Sanchez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True, ma'am.
Your Honor, state waives all the violations.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 2? All right, you're whispering.
Yes, ma'am.
All right. Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor, it's for 2 years TDC.
That is our proposed agreement, Your Honor.
All right, why should I give her the minimum? What has she done on probation?
Judge, I can tell you that she did complete drug court. Unfortunately, she kind of fell short in reentry court. She had tons and tons of negative UAs. She had been working really, really hard. I believe that the underlying offense was 7 grams. So I know it's 4,200, but it was closer to the 4 than it was 200. And Judge, she does have, I think, 139 days in jail. She just really just wants to put this behind her and move on with her life. She tells me she's been working for 2 years at the Tower of Americas. She's hoping they'll keep her job open for her, depending upon how, if you follow the recommendation, how long it takes for her to parole. She's got a house that she bought. Her kids are living in it. They've been paying the rent. She's hoping that will sustain itself on, but Judge, she just wants to put this behind her and move on, but she did do a significant amount of work on this probation.
All right, do you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand. State your name for the record.
Jacqueline C. Sanchez.
All right, why didn't you do well in
Here's the heart of the conflict: relapse. Sanchez claims she drank 4 beers, but insists that was the issue. The judge pushes back: no, drug court understands relapses. Translation: the problem wasn't just the relapse, it was the lying. This is where credibility becomes everything. Judges can often be more forgiving of someone who stumbles but admits it, than someone who hides or manipulates. Sanchez's own words, "They felt like I played them," are devastating to her case. Addiction may explain behavior, but dishonesty destroys trust, and in court, trust is currency.
drug court?
I'm sorry, what was that again?
Why did you not do well in felony drug court?
I didn't have the money to pay for the UAs, ma'am.
No. Felony drug court usually will not remove you from their program because you can't pay UAs. Are you telling the court that you were removed from felony drug court because you couldn't pay for the UA?
And I had a relapse. I had drank 4 beers, ma'am.
Judge, she actually graduated from drug court, I believe, and then she went to the reentry. So I think she completed drug court. So I don't think she had a problem doing drug court. I think it's when she got out.
So here's my question. Why did they remove you from their reentry program?
Because I drank 4 beers, ma'am, on the 23rd.
No, usually it's more than that because felony drug court usually understands relapses. Am I wrong in that? Did they not understand that you had a relapse?
They usually do, ma'am, but this time they felt like I played them.
What do you mean by they felt like you played them?
They felt like I was lying. I lied to them.
Okay. All right. Probation.
Judge, the note that was received from drug court was.
Well, just one second. Any objections to probation giving me some insight in whether or not I should follow this agreement?
Okay.
And also, they found on my phone that I was trying to get, methadone for a friend because he relapsed and he was trying to get clean, and that's what I was doing. And I had somebody else ask me I was looking for marijuana for some.
And now the bombshell: text messages showing Sanchez was looking for drugs, methadone and marijuana, not just for herself, but for others. This flips the narrative. Up until now, she was framed as someone struggling with personal addiction. But here, the implication is she may be facilitating access for others. Whether or not she actually completed the transaction doesn't matter. The intent alone is a serious red flag. Judges view this as moving from personal struggle into the territory of enabling or even trafficking. This revelation all but seals her fate.
Somebody.
Wait a minute, what?
I was looking for marijuana for somebody. They asked me to look for it. They text me if I could find it, and I told them, yeah, but I never got to doing that.
Oh, so now we're getting to the point. So you were in felony drug court in the reentry program and you were looking for drugs for other people.
Judge, I think she was looking for methadone and possibly marijuana. She's not, the perfect probationer, but that's what she told me, Judge. I don't think it was.
I made a mistake, Judge. I'm sorry about that.
Nope, you made choices. They're not mistakes, they're choices. All right, is there anything else?
Judge, again, we just ask that you consider the fact that she did spend a lot of time in drug court. She has been straightforward with you, I believe. And ask you to follow the state's recommendation of 2 years TDC.
All right, and do you want me to hear from probation or no, counsel?
Sure. I don't think my client's trying to hide anything, Judge.
Okay. Probation?
The information that was received from felony drug court was she did finish the program successfully. However, during the aftercare portion, there were UA tests with positive ETG results, and a phone search was conducted and text messages revealed.
Probation steps in to confirm everything. She did complete drug court, but afterward, her UAs showed alcohol, and her phone revealed drug-seeking behavior. This independent verification is key. Courts rely heavily on probation officers for insight because they have first-hand oversight of the defendant. Once probation lays it out plainly, it removes any last wiggle room. At this stage, the defense's plea for leniency is overshadowed by hard evidence. It's no longer about whether Sanchez wants to change, it's about whether she can be trusted to.
That he was communicating with negative contacts and negotiating the sale of illegal drugs.
Okay.
I did reach out to felony drug court to see if they would be willing to accept for that, and at this point they are not.
All right, so this is what the court is going to do. As previously stated, the court is finding violation of condition number 6 true.
So I think it's,
I'm sorry, number 2 true.
Yes.
Thank you. The violation of condition number 2, the court is finding that to be true. There's a $1,000 fine. Time and money were run concurrent. Was the $57 ever paid for the laboratory testing? Do you know if you ever paid that?
Drug court? Is it
Ah.
to drug court? Okay.
Okay.
No, I have not taken.
Okay. There should be $57 restitution to SAPD for laboratory testing. If you would like, I could have you referred to the therapeutic community. It doesn't increase your time at the prison. It's just something to hopefully help you maintain your sobriety.
Okay, I'll take that.
All right, therapeutic community.
And there it is, the final ruling. 6 years in prison. The judge even offers therapeutic community support in hopes of rehabilitation, but ultimately, accountability wins out over leniency. Let's recap. Sanchez started with a plea deal and the chance to walk away clean. But repeated violations, dishonesty, and evidence of seeking drugs for others left the judge with little choice. This case highlights the brutal balance courts must strike between offering second chances and protecting the community. White right pointing backhand index. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns. Every case tells a story, and we'll be here to break it down for you.